Yes, Mr. Jordan.
Lords, my lady, in this appeal I appear with Mr. Benison on behalf of the second defendant and appellant, O.G. Thomas Amaethyddiaeth Cyf, which I will refer to as the company, as in our skeletons. My late friend, Mr. Radley Gardner, King's Counsel, appears for the claimants and respondents to the appeal. As the court knows, this is an appeal from the order of Justice Zacaroli, dated the 26th of May 2022, in which he dismissed an appeal from the order of His Honour Judge Jarman, King's Counsel, dated the 20th of January 2022. And it's brought by permission given by Lord Justice Arnold.
Yes, we've read both the judgments and we've read the various skeleton arguments.
Very good. Would it assist if I explain the rather unusual procedural history of this case that's led to this point?
Is it relevant?
Not very relevant.
Then don't.
Very good. I should explain the facts briefly, although the court has seen those.
Well, there's an oral tenancy. It was assigned by deed of assignment by Mr. Thomas to his company.
Yes.
And a notice was then addressed to Mr. Thomas purporting to terminate the tenancy.
Yes.
And the notice complies with what such statutory requirements as there are for notices under the Agricultural Holdings Act. And the question is, was it given to the tenant?
Yes. Yes, my lord. The notice itself is in the appeal bundle at page 170 behind tab 18.
Yeah.
And since the court is concerned to interpret it, it was sent by
So you say that this is a question of interpretation of the notice, do you?
There are two issues in my submission. The first is one of interpretation of the notice, and the other is that assuming the notice is not to be interpreted as addressed to the company, is the defect saved by Section 93 of the Agricultural Holdings Act 1986, which is a point that was found against the claimants by His Honour Judge Jarman, but is revived by a respondent's notice in this court.
So you just to get this clear, you don't say this is a blue paper versus pink paper point. You say it's a question of interpretation of the notice.
It's a question of identifying to whom the notice was given, and if a typographical error in a notice can be corrected as a matter of interpreting the language and seeing an obvious mistake has been made. So if the notice, if Mr. Thomas had remained the tenant, but his name had been misspelt, but it was obvious it was intended for him, then as a matter of interpretation of the notice, it would have been a notice given to him, addressed to him. If the notice had simply been addressed to the tenant, or if as a matter of interpretation it is to be read as addressed to the tenant, whoever they may be, then it is a valid notice. If it is to be understood objectively as addressed to Mr. Thomas as tenant, then it is a bad notice unless Section 93 saves it.
Looking at the notice on page 171, does that mean that if you'd taken out the words to Owen Gwilym Thomas, it would be a good notice?
If it had said to the tenant...
Or just take out that line entirely. Just say, I, as executor, give you notice to quit and deliver up possession of all that holding in premises, etc., which you hold of me as tenant. That would be a good notice.
It would have to have been delivered by a different means, but if it had been put into Mr. Thomas's hands and it had not been addressed to him, it had been addressed to the tenant.
I suppose it wasn't addressed to anybody. Just say, I give you notice to quit.
Yes.
The lands which you hold of me as tenant.
Yes.
And it had come to the hands of Mr. Thomas.
Yes.
That would be sufficient.
Well, if it had been given by Mr. Owens to Mr. Thomas, and it had said, I give you notice to quit, then that would have been a good notice. But it wasn't. The covering letter was addressed to Mr. Thomas at his home address. It began by saying to Owen Gwilym Thomas.
Well, it was also addressed to Mr. Thomas at the registered office of the company.
Yes.
And he was the sole director and the secretary of the company.
He was, my lord, yes. It was addressed to Mr. Thomas, not to whoever may be the tenant, or silent as to who the addressee was. It was specifically directed to Mr. Thomas. And it said, I give you notice to quit and deliver up possession of the holding, which you hold of me as tenant.
Yeah. So it all turns, as my lord says, on that single line in the notice to quit. If that line hadn't been there, I think as you accepted, that would have been a good notice.
Yes. That's not unusual with notices, that a line or a word or a number can validate or invalidate the document. So as I say, my lord, there are these two issues. Is this notice to be treated as one given to the company as the tenant, as the judges in the courts below held? And if not, then does Section 93 authorise giving a notice to Mr. Thomas rather than to the company? And they're both pure issues of law. They don't turn on any factual evaluation, and therefore, although the respondent's skeleton argument spend some time addressing how the arguments were put in the courts below, I don't propose to.
Well, the whole case was decided on agreed facts.
Yes. And I had proposed to open the appeal by addressing our ground of appeal, and then to deal with the respondent's notice point in reply, if that's a convenient course.
Yes. Just before you do, I came across this morning a case called Lazarus Estates and Beasley, which you might want to have a look at. So I've got a couple of copies for you.
Thank you.
Is there Usher here? Could you give those to counsel, please? I'm not asking you to do that now, obviously, but at some point.
Thank you. I'll give it to Mr. Benison to take care of. So, my lord, the way I proposed to approach my submissions was by beginning by identifying why it is that the notice to quit would be ineffective unless interpreted as addressed to the company, subject to Section 93. And then what we say the scope is, the proper scope is of the Mannai principle for correcting errors. And then I'd like to take the court to the four authorities on which we principally rely, which are the Morris case, the Linney case, which my Lord Justice Lewison decided in the High Court, the Ben Cloyce case, and the Belgray case, the last two being decisions of the inner house of the Court of Session, which are not binding on this court, but are persuasive, which I submit means that unless the court considers that Scots law is different to English law, they should be followed unless this court is convinced that they were wrongly decided. And I would then address the claimant's argument that the law is different in Scotland, which in my submission is not the case, and then seek to apply the principles to the facts here, and then identify what we say are the errors in the judgments below. So the place to begin is, why would the notice be of no effect unless given to the company? Well, the first submission, which I don't think is in dispute, is that after an assignment of a tenancy, a notice to quit has to be given to the current tenant, not the previous tenant. Both His Honour Judge Jarman and Mr. Justice Zacaroli held that was so, citing Old Grovebury Manor Farms and Seymour Plant Sales, which was a case about a Section 146 notice, but the same principles apply to a notice to quit. Certainly the respondent's skeleton argument doesn't take issue with the point. But it is worth noting that it was a point that went all the way to the Court of Appeal. So perhaps not that clear cut. But that does mean that the notice to quit had to be addressed to the company. And then the second point...
Well, you've elided two propositions. Notice to quit must be given to the current tenant. Agreed. But there are two bits to giving. One is to whom must it be addressed,
yes.
And the second is on whom must it be served.
Yes.
So Old Grovebury, the Section 146 notice, was served on the previous, addressed to and served on the previous tenant. And the same is true of Linney, where the break notice was addressed to and served on a previous landlord. Now, Section 93(2) may or may not validate service. I think you accept that it does.
Yes.
So the only question really is, must the notice be addressed to the current tenant?
Yes. And a notice which tells somebody to leave land has to identify the person who's being told to leave a land. A notice to quit is just that. You must leave, you must give up possession, you must be gone. And therefore, it's vital that the notice addresses either by name or by characteristic the person to whom it is addressed. So that is the concept of giving or addressing and the concept of serving are, as my Lord says, quite separate questions, as the authorities make clear. In the Linney case, which we will come to, the notice was also served on the agents for the correct landlord, the person who needed to be given the notice, but we'll come on to that. But it was served on both the wrong person and the right person, but it was addressed to the wrong person.
Well, it was served on the agent.
Yes, Jones Lang.
Yeah.
So the second submission I have, and here we disagree with the respondents respectfully, is that at common law, where the tenant is a company, the notice to quit does have to be addressed to the company and not its officers. To start, may I go to the bundle of authorities, please, and to tab 32. And page 394. The pagination is in the middle of the page, right at the bottom.
This is Woodfall, yeah?
This is Woodfall, which my Lord is the general editor of course, and paragraph 17.239 says, where a corporation aggregate is the tenant, notice to quit should be addressed to the corporation and not to its officers. But a notice to quit addressed to the director of a company tenant, which on its proper construction directs the company to quit, is good. And that is the law, the common law, subject to anything that Section 93 may have to say on the subject. The first case that's footnoted is one called Doe on the Demise of the Earl of Carlisle and Woodman from 1807. We have that in the bundle, but
I find that a case that's very, very hard to understand. I was hoping you might explain it to me.
I shall do my best in that case, my Lord. It's at tab 6. And may I invite the court to read the head note?
Yes.
And then the facts are set out in about 12 or 15 lines immediately beneath that. In fact, I invite the court to read down to the line which says, with the notice to quit and had not hitherto paid any rent.
So you've got a letting to the corporation, seems to have been managed by bailiffs,
Yes.
elected annually or appointed annually, and the notice is served on 2 bailiffs.
Yes.
And
Two newly elected bailiffs.
yeah, and they say they're not in possession.
Yes.
Therefore, they're the wrong defendants to an action in ejectment.
Yes. And the trial judge gave verdict for the plaintiff, made an order for possession against the bailiffs, and then...
Yes, he says that the bailiffs, by reason of their office, had the actual possession,
Yes.
and therefore they were in possession, and therefore they were the proper defendants to the action for ejectment, but he gave them leave to move for a
Yes.
non-suit. So this is all about non-suiting.
Yes.
Yeah.
But it is... The reporting could be more extensive and more illuminating, but what is apparent from both the note of the argument and what at least 2 of the judges said is that there were 2 issues that the court was considering. One was whether the bailiffs were the tenants, to which it was said they were not. And the other was how could the landlord terminate the tenancy and recover possession given the difficulty of the bailiffs being there on behalf of the corporation rather than tenants in their own right.
So Lord Ellenborough seems to say they haven't got possession. They're representatives of the corporation, so they're not in possession.
Yes.
The argument was that the bailiffs from year to year had always paid the rent. Therefore, these bailiffs were liable because rent had been received from previous bailiffs. And Lord Ellenborough says that they're not a corporation, so they're not affected by what previous bailiffs have done. So they've never paid any rent.
Yes.
And Mr. Justice Lawrence says trespass can't be maintained against the corporation. Why does he say that?
Well, we've tried to answer that. Mr. Benison has investigated it, and he says he can't come up with an answer because colon ejectment has a whole chapter on claiming possession against corporations. So we're as puzzled as my lord is on that point.
And then he says, at any rate, the tenancy may be determined by notice to the corporation served on its officers. He doesn't say that's the only way it can be determined. He says that's how you can do it.
Well,
and then you can distrain against anybody's cattle that's on the land.
yes, but if one looks at the note of argument by 3 counsel, Parkwood and Carr, it is said, inasmuch as the corporation, qua corporation, could not have an actual possession or commit trespass, and having no visible being could not be served with a notice to quit, it would be impossible to serve every individual corporator. Their occupation could only be by their officers or tenants, and these only could be served with notice to quit as had been done in the present case. So they were relying on the notice to quit that had been given to the defendant officers of the corporation. And then they said the bailiffs, by coming in to defend, admit themselves to be in possession as tenants. And Mr. Justice LeBlanc says that the tenants, the defendants, the 2 newly appointed officers of the corporation, had never paid any rent, and they couldn't be affected what the previous bailiffs had done. And then he says, though it is rather evidence that they paid the rent on behalf of the corporation, and when the tenancy is determined, the lessor will have his remedy against any person in possession.
But he doesn't go into how you determine it.
No, but it is... He clearly doesn't consider that the notice to quit given to the bailiffs had determined the tenancy. And if it had been considered by the court that the notice to quit given to the bailiffs had determined the tenancy, then ejectment would lie against anyone who was on the land.
Yeah.
So, although I...
Is that right? I'm afraid my knowledge of ejectment is rather rusty. You're entitled, if you're entitled to possession, to an order in ejectment against anybody, be they trespassers or former tenants or anybody else.
The order is enforced by a writ directed to the sheriff, directing the sheriff to evict anyone on the land.
Presumably, in order to get a writ of ejectment, you have to bring an action in ejectment against someone in possession. Is that the idea?
Yes, that's the...
Well, the whole point of this case is the bailiffs weren't in possession.
or they were in possession on behalf of the corporation. So there were 2 points in the case. One is, were the bailiffs in possession? And the other was, had the tenancy been determined, and if not, how could it be determined? Which is why Woodfall cites it as authority for the proposition that a notice to quit must be addressed to the company and not the officers of the company, because it is the company that needs to be told to leave and not its officers. The other case that's referred to in Woodfall is Hawtrey and Beaufront, which Woodfall cites as an example of a case where, although the notice was addressed to the officers, it was to be understood as a notice to the company. And that one is at tab 10 of the authorities bundle. And the key passage is on the last page of the law report, page 93 at the bottom. It was a case where the tenant was called Beaufront, and then the notice itself is summarised on the previous page, the last break of paragraph. After being addressed to the directors of Beaufront Limited, it goes on to say registered office, formerly at Beaufront, Camberley, Surrey, but now at Marks Barn, Crewkerne. And then over the page, Mr. Justice Croom Johnson, at the paragraph beginning a limited company, discusses the validity of the notice. May I invite the court to read that paragraph, please?
Yeah.
So he partly applies a subjective test, which many judges did apply until Mannai made it clear that the test is purely objective. But he also takes an objective approach and says any solicitor looking at this document would see that while it's addressed to the directors, it's addressed to them not in their capacity as tenants or as parties to the agreement, but as being the persons acting on behalf of the limited company. I think, therefore, in a fair construction of a document, it is a good notice to the defendant company. So, in our submission, Woodfall accurately states the law as one would expect. Notice that common law has to be addressed to the company, not to the officers, unless it is apparent that the officer is simply being used as a way of referring to the company.
Yeah.
Where does he refer to the subjective intention of the...
He says they knew all about it. They had been warned about the declaration by the Prime Minister.
Oh, I see. You don't mean the subjective intention of the person giving the notice?
No.
The subjective understanding of the recipient?
There are some cases, quite a number of cases, where judges have focused on how the recipient actually understood and acted on the document and deciding what it meant, but that's now been overruled by Mannai.
Can I ask you something else? Is dubity a word? Not one I've come across before.
So where is it?
8 lines down from the top on the last page. The only dubity arises from the use of the word you.
I think I'm going to say pass on that one.
Dubiety, I think, is a word, but not dubity.
No, it's very doubtful.
My learned friend can help with information on that point. So that is why we say that the notice sent by Mr. Owen addressed to Mr. Thomas can only be a valid and effective notice to quit if it is interpreted as addressed to the company and not to Mr. Thomas. And of course the judges in the courts below held that it could be so interpreted, it should be so interpreted by reference to the Mannai principle. So may I turn to that case now? That's at tab 14. I'm looking at the pagination at the bottom of the page, from page 168, the judgment of the speech of Lord Steyne. The facts were very straightforward and are set out at letters D to F. So may I ask the court to read?
Yeah. Yeah, you got the wrong date.
Yes, the right clause. The letter that was sent in the case of each lease is quoted at letter F, and it said, pursuant to clause 713 of the lease. So they got the clause right. They got the right that they were seeking to invoke correct. It was clause 713. And under clause 713, the notice had to expire on the 3rd anniversary of the term commencement date. So, taking my Lord Nugee's approach, if one had simply, if the notice had simply said, pursuant to clause 713 of the lease, we, as tenant, hereby give you notice to determine the lease, there would have been no doubt about its efficacy. It was the addition of the specific date that caused the problems and caused the Court of Appeal to say that the notice was void, and caused 2 of the judges in the House of Lords to say it was void. And there was obviously a conflict between the first part of the notice, which referred to clause 713, and the last part, which gave a date. And in our submission, the ratio is that the obvious error was the date and not the clause. In a case where the sender was apparently, evidently, obviously, seeking to exercise the right given by clause, they'd identified the right clause and the right. What they had got wrong was the language used to express what they were trying to communicate. It wasn't a case about an error about what the sender was trying to communicate, but as to the language used to communicate it. And the first point that we invite the court to take from...
Well, I mean, it depends at what level of generality you pose the question, doesn't it? You say there's not an error about what the sender was trying to do. Well, the sender was trying to terminate the lease.
Yes.
And the giver of the notice to quit, in our case, was trying to terminate the tenancy. So in that sense, there's no doubt about what the sender was trying to do. So it's a question of what level you pitch the question.
I see that, my lord, but the answer to that is given by the concluding part of Lord Steyne's speech, which we will come to, where he says this is a narrow approach, not a broad approach. But maybe I'll look at it now.
Sorry, where are you reading from?
It's pagination at the bottom, page 175.
175.
Letters A to C.
Yeah. Yes.
So, first of all, no doubt whatever, in the first paragraph. In other words, it's a very tight test. And secondly, I do not accept the extreme argument of counsel for the tenant that whenever a notice to determine refers to a break clause, or whatever the other circumstance of the case, the notice must be valid. That goes too far. So he clearly considers that it should be kept in tight rein, this principle. And then he says, in the present case, it would have been obvious to a reasonable recipient that the notice contained a minor misdescription, and that the notice conveyed that the tenant sought to determine. So the question was, what did the notice convey that the tenant was seeking to do? And what the tenant was seeking to do was exercise the right under the clause, which said it could be determined on the 3rd anniversary of the term commencement. And 12 was an obvious error in communicating that intention. That makes it clear that this is not as... And we'll see that when we look at the cases under the agricultural holdings legislation, which we refer to in our skeleton list. It's not enough to see that somebody's trying to do something which they can only do in one way. They have to get the right. They have to be apparently exercising the correct right. So in our submission, if the letter from the solicitors had just said, we as tenant hereby give you notice to determine the lease on 12th January 1995 and had not referred to clause 713, it would have been void. It was the fact that it began by saying pursuant to Clause Law 713 that validated it. One important question in this case is whether the fact that the tenant was in fact the company is to be treated as information to be used in interpreting the notice. One of the crucial issues in the case. And both of the judges in the courts below said that it was. They said it was a fact that would be known to the reasonable recipient, that the tenant was the company, and therefore would be interpreted with that fact in mind. And our submission is that what one is concerned with, as Lord Steyn put it in the paragraph we just looked at, is what is it that the notice is conveying, that the sender is trying to do. And so one was concerned with the facts known
Sorry,
to
where
the...
are we?
So that's page 175, letter C.
Letter C.
The
The notice is conveyed, yeah.
Yeah. That is the question. What objectively is the information that the recipient would understand the sender to be conveying? One isn't concerned with what is in the actual mind of the sender, but one is concerned with what the recipient would reasonably understand the sender to be conveying. And in our submission, a fact that is not known and not reasonably available to the sender can't be used to interpret the language used. And we
Could the landlord have discovered, by any reasonable means, that the tenancy had been assigned? You said not reasonably available to the landlord.
he could have asked, but
If he'd asked, he might have got an answer and we wouldn't have this problem. But I mean, normally landlords don't, every time they write a letter to their tenant, say, are you still the tenant?
No.
Could the landlord, in this case, have reasonably discovered, except by asking the tenant, which there was no reason to think that he should, that the tenancy had been assigned?
the answer is no, my lord, but it's also the case that there are two things that Mr. Owens could have done, should have done, which a reasonable landlord in his position would have done. First of all, serve a Section 6 notice.
On whom?
On whom?
Well, before the assignment on Mr. Thomas.
We didn't know about the assignment. The assignment could have been earlier than it was.
Well, oral tenancy of agricultural holdings are not unknown.
No, I think they're quite common.
But a well-advised landlord will always serve a notice under Section 6 of the 1986 Act or its predecessor. And once such a notice has been served, requiring that the tenant agree or that there's an arbitration on the terms of the tenancy, once that notice is served, the tenancy can't be assigned, puts a block on assignment. And it also leads to there being a written tenancy agreement, either by agreement or by imposition by an arbitrator. And the second thing that a landlord can do, and many landlords have done, is address a notice either to the tenant without a name or to so-and-so or other the tenant. It's the same as with a notice to quit, where you have to get the date right. It has become standard practice to say at the end, after the date that you specify, and indeed that happened here, or rather the date on which the next complete period of a tenancy will expire after the service of this notice, saving words. So those are two things that could and should have been done, either of which would have avoided the problem. But no, the answer to my Lord's question is no, there was no way Mr. Owens could have known about the assignment. It wasn't a registered lease, and therefore there was no register that could be inspected.
You say it was very simple because in the notice you just put, if you mentioned it at all, you put to Owen Gwilym Thomas / the tenant.
Yes. And indeed, the judges below interpreted the notice as if those words had been there when they weren't. So, my Lord, one point that we want to draw attention to in Mannai is that both Lord Steyn and Lord Hoffman reached the conclusion that they did by analogy with the interpretation of contracts, of bilateral agreements, If one looks at page 181, again, pagination at the bottom,
Yeah.
starting at letter F in Lord Hoffman's speech, if I could invite the court to read from letter F on that page over to letter C on the next page.
It's quite odd, Mr. Jordan. I mean, we're obviously bound by what this case decides, but both Lord Steyn, who describes it as a misdescription case, and Lord Hoffman, who describes it as a verbal error, seem to have assumed that what went wrong was the landlord meant to write 13th of January, but for 12th of January by mistake. But that seems to me to be highly unlikely. It seems to be much more likely the landlord misread the lease and meant to write 12th of January. But why is that a verbal error or a misdescription?
Well, my lord, because one is focusing on the reaction of the recipient and what it is that the sender is trying to communicate. What he's trying to communicate is he wants to exercise the right under the clause in the lease that says it can be brought to an end.
I think Mr. Patton argued that point, and Lord Steyn rejects it at page 174 in our bundle, between D and F. Tenant's error may have been due to mistaken legal view.
Yes.
Lord Steyn says, well, that's irrelevant.
Yes, Lord Steyn treats it as an illegitimate inquiry into what was going on in the mind of the person who wrote the notice.
Yes, well, that's what you are asking us to do, isn't it? You're asking us to go to look into the mind of the landlord and say, well, what did he mean? That must be because he didn't know about the tenant having changed. He must have meant to serve Mr. Thomas. Isn't that what Lord Steyn is saying he shouldn't be doing?
Well, my lord, no. What Lord Steyn is saying is that one shouldn't conduct an inquiry into the subjective state of mind, but it's apparent from what he said elsewhere and from what Lord Hoffman said that what one needs to do is to apply the same principles as in a commercial contract, identify what the words would be understood to mean by the reasonable recipient receiving them, and with a commercial contract, the facts that are taken into account are those known to both parties, not just one party.
Is the same true of a notice?
Yes.
In terms of the factual background, because we're concentrating here on what the recipient understood, rather than looking for the mutual understanding of both parties, or the reasonable reader with the knowledge of both parties.
What the recipient understood the sender to be attempting to communicate by the document. And what the sender attempted to communicate by the document can't be influenced by things that the sender did not know.
And how do you explain the Waterman's Arms, Bricklayer's Arms case on that basis? We just simply don't know why the landlord got the wrong pub.
No, but the reasonable recipient, seeing a reference to a non-existent pub, seeing that case is...
Can't remember which one it was. Lord Hoffman refers to it.
It's at tab 7.
Yes, it's Don the Demise of Cox and Row. Lord Hoffman deals with it at 177.
Take notice that you quit the premises which you hold of me. So that starts off making it perfectly clear what the sender is referring to. It's the premises held of the landlord, situated and commonly called or known by the name of the Waterman's Arms. Well, given that there is no Waterman's Arms, given that the notice is plainly trying to identify the pub held of the landlord, it's on all fours with Mannai. Exactly the same situation. Clear what the sender is trying to communicate. Clear that they've made a verbal error in communicating it. And one can see plainly and obviously and without any reasonable doubt what it is, what the error is and how it should be corrected by reference to facts known to both parties. Namely, there is only one pub and it's not called the Waterman's Arms, it's called the Bricklayer's Arms.
But would not the reasonable recipient in Mr. Thomas's shoes say, well, there aren't any premises which I hold of this landlord because I have assigned to the company, so he must mean the company.
Well, no, my lord, because Mr. Thomas knows, this is only one point, but he does know that the assignment has only just happened. He hasn't yet told the landlord about it. It's not a fact that's reasonably able to both parties to the contract, but only to one of them. Therefore, it can't influence the interpretation that a reasonable reader would place on the document. If I could ask the court to go back to Mannai just for a moment. Page 178 of the bundle. Just below letter C in Lord Hoffman's speech, in the second sentence he says, what does it mean to say that a document must be strictly construed as opposed to a normal process of ascertaining the intentions of the author? And that is consistent with what Lord Stayne said. Both in the passage we've already looked at and in one at page 170.
Yeah.
Right at the bottom of page 170, Lord Stayne said, crediting a reasonable recipient with knowledge of the terms of the lease and third anniversary date, 13th of January, I venture to suggest that it's obvious that a reasonable recipient would have appreciated that the tenant wished to determine the leases on the third anniversary of leases, but wrongly described it as the 12th instead of the 13th. So he too says that what you're trying to do is work out what a reasonable recipient would have appreciated that the tenant was wishing to do. As Lord Hoffman put it, you're trying to ascertain the intention of the author, not what's actually in their head, but what intention is the document communicating. May I just look at one example that Lord Hoffman gave as well, about on page 176, at letter G.
Yeah.
He gives the example, if one meets an acquaintance and he says, and how is Mary, it may be obvious that he's referring to one's wife, even if she's in fact called Jane. He's giving that as an example of a verbal error, a bit like the Bricklayers and Waterman's Arms example. It's clear who it is, what individual is intended to be identified, the wife, and clear that what's gone wrong is the word used to refer to the wife, Mary instead of Jane. But if the man had previously been married to Mary and was now divorced, married to someone else, then the man wouldn't understand the acquaintance to be referring to his current wife. He would appreciate that a mistake had been made, but not a mistake in the intention that his acquaintance was expressing. The mistake was in thinking he was still married to Mary, a fact which is unknown to the speaker. And the words used by the speaker can't be interpreted by reference to facts that the speaker does not know.
What about Mrs. Malaprop? She didn't just make a verbal mistake, she made a zoological one. Because you don't find alligators on the banks of the Nile.
Yes, indeed.
You can correct that too.
Well, she intends to refer to a scaly...
What if she didn't know that there were crocodiles rather than alligators on the banks of the Nile? Still make that switch?
Well, my lord, one would understand her to be saying that something is as obstinate as an alligator on the banks of the Nile. Not clear, I have to say, why alligators are thought to be particularly obstinate, but apparently she thought they were. And the significance of the communication is about obstinacy. So whether there are crocodiles or alligators is immaterial. But if it mattered, if it was crucial to distinguish between alligators and crocodiles, one would be saying, well, she thinks that there are alligators and there aren't. Lord, we have given, it's clear from what Lord Steyn said in the passage that we looked at on page 175, that there are types of error that cannot be corrected as part of the process of interpreting a notice. And obviously the question in this case is the error that was made here in referring to Mr. Thomas rather than the company in the category of errors that can be corrected or in the category of errors that can't be corrected? We, of course, admit that it's in the latter category. So it is helpful to look at cases where the courts have said that the error can't be corrected. And most of the ones we've cited are about getting the name of the addressee wrong. But I want to just briefly look at a different category of case where the error was getting the right wrong, which are both cases under the agricultural holdings legislation. Mountford and Hodgkinson and Stradbrook and Mitchell. I'm only proposing to look at the second of those because it refers to the first. And that's at tab 21. So, with a tenancy of an agricultural holding protected by the Agricultural Holdings Act 1986, a landlord can serve a notice to quit, not specifying any reason as in the present case. In that case, the tenant is able to protect themselves against the notice by serving a counter notice within 1 month requiring section 26 subsection 1 to apply. And if that is done, the notice to quit doesn't have effect unless the landlord applies to a tribunal and the tribunal consents to its operation, which can only be the case if certain grounds are made out. But a landlord can also serve a notice to quit that does specify a reason for giving the notice to quit, a reason by reference to one of the cases specified in Schedule 3, one of which is Case E, if the landlord says that there has been an irremediable breach of covenant causing material prejudice to the landlord's interest. And if a Case E notice to quit is served, the way the tenant protects themselves is by serving a notice requiring arbitration on the reasons specified in the notice. And that has to be served within a month as well, but it's a different type of notice. And what happened in the Stradbrook case is that the landlord served a Case E notice to quit, saying that it was served because the tenant had committed irremediable breaches causing material prejudice. And the tenant served the sort of counter notice you serve if you're served with a notice that doesn't specify a reason, a notice requiring section 26 subsection 1 to apply. And the notice is at page 296. In the left-hand column between letters B and D, I hereby give you a counter notice that I require subsection 1 of section 26 of the Agricultural Holdings Act 1986 to apply. And the question was whether that could be interpreted as a notice requiring arbitration. And Mr. Justice Aldous held it could not. In the end, the tenant won for a completely different reason, because the judge held that the notice was fraudulent because the sender had no reasonable belief, no real beliefs rather, in the truth of the allegations he was making. He was reckless as to whether they were true or not. And that point went to the Court of Appeal, which upheld his decision. But on this point, there was no appeal. Page 297, in the left-hand column under the heading of the counter notice, could I please invite the court to read from the counter notice down to the end of the paragraph beginning at letter F.
just explain, could you just explain paragraph F? What the judge says is, a person having a working knowledge of the act would realise that the error had been made, but a person who did not have such knowledge would not. So, how does that feed into the equation?
At this point, he says he's finding the facts.
Right.
So that's what he says as a matter of fact.
Yeah.
And then if one looks at the opposite column, the right-hand column, where the green sidelining is at letter D.
Letter D, yes.
He states the test that he's applying.
K, I think, actually, but never mind.
So he refers to an ordinary landlord.
Yes.
But if you're letting agricultural property, why is that not an ordinary landlord of agricultural property? I mean, in reality, earls and such like who own large amounts of land and let them to agricultural tenants do have a working knowledge, either themselves or through their agents of the Agricultural Holdings Act. Why is that not a relevant fact?
Well, at this point, he's simply identifying the test that should be applied to decide whether the counter notice was valid or invalid. And he's doing that by reference to an earlier rent review.
Yeah,
case.
ordinary landlord.
But this was before Mannai was decided, but nonetheless it is, in my submission, clear that the test is the Mannai test. He was applying the right test. Counter notice should be in terms which are sufficiently clear to bring home to the ordinary landlord that the tenant is purporting to exercise his right under the provisions of his lease, under the provisions of certain legislation. That's taken from a case called Nugee, Davis, Lang and Dick, which he discusses higher up.
Yeah. But is the ordinary landlord imbued with a working knowledge of the Act or not?
Well, what he says when he comes on to discuss the point on page 298 at just below letter F, he says, if a landlord had a working knowledge of the law, he would suspect that a mistake had been made. And then he says to adopt that approach would mean that nearly all counter notices which made it clear that the tenant was challenging the notice would be sufficient. That approach would be contrary to the reasoning of the Court of Appeal in the Mountford case, which I was going to show the court on the way. But that's the end of this journey. He says he doesn't decide the point whether you treat the landlord as having a working knowledge or not. He treats that as a matter where it doesn't really matter, because even if he does have a working knowledge, it isn't sufficient to cure the defect.
Well, I'm not sure about that. If the landlord had a working knowledge, he would suspect a mistake had been made.
Yes.
Such a landlord. That's the ordinary landlord, he's referred to in the previous paragraph.
Yes.
To read the counter notice in the way suggested required knowledge that the only procedure available to challenge the notice was under section 26(2), and entails the landlord amending the notice because of that knowledge, i.e. the landlord doesn't have knowledge of the Agricultural Holdings Act. Because if he did, he would realise what the tenant is attempting to do.
Well, it requires two steps. First of all, knowledge of an error.
Yeah.
Which he doesn't make a finding on. The second is, and then having knowledge of the error, amending the notice because of that knowledge.
Yeah.
That's a step he says is impermissible. It's a step too far to correct an error of this kind. It is an example in my submission of an error of the kind that Lord Steyne referred to as being one which couldn't be corrected. And he, as one can see, Mr. Justice Aldous, later Lord Justice Aldous, refers back to the Mountford case, which he summarises on page 297 in the bottom right-hand corner. It is in the bundle, but perhaps I should show the court the case itself rather than Mr. Justice Aldous' summary of it. It's at tab 15.
Before you do that, therefore, what you're saying in relation to what's set out at 298F is, because of the very nature of the error, it is something which would require amendment. And as soon as you get into that category, then it's not something one ought to be doing. It's sufficiently great a mistake, in inverted commas, that it requires amendment rather than, oh yes, that's obvious. And therefore you're saying it's in that different category. Is that right?
My lady, as quite often with these cases where some things do fit a test and some things don't, defining the precise point where one crosses the line is extremely difficult, and my lady's way of doing it may be the right way.
No, I'm not sure that it's my way at all. It's just that I'm taking it up from the idea that there were two stages. First, you recognise there may have been a mistake, but it's a mistake of a kind that needs actual amendment. And if one is in that category, and I'm asking whether that's what you're saying, that we're in this category here, that one would have to amend, and as soon as one has to amend, that's a bridge too far, rather than the kind of category which would be, and oh yes, that is obviously what they meant, and that would be fine. And I'm asking you whether you're making that division.
Amendment might be a convenient shorthand, but one has to go behind that, I suggest, and find out what counts as an amendment and what doesn't. And the approach that we suggest is the right one, which distinguishes Stradbroke and Mitchell and Manford and Hodgkinson from Mannai and the Cox case, the Waterford Arms case, is in the Stradbroke and Mitchell case, it was clear what the tenant was saying. He was saying, I want section 26(1 to apply. And it was obvious he'd made a mistake, but not a mistake in expressing the intention. If he'd said 26A1, for example, and there was no 26A1, it would be obvious he meant 26(1, but there was no error in the language used. What was the error was he'd chosen the wrong right to exercise. And that is the sort of error which in our submission Mannai can't apply to, as Lord Steyne made clear at the end of his speech.
Thank you. I'm sorry, you were going to Mountford.
Yes, please. That's tab 15, page 187. And if I could ask the court to look at the bottom of page 188, just to see the legislation as it was then. Back then it was the Agricultural Holdings Act 1948, and section 24 is set out there. So what was required is the tenant serves on the landlord a counter notice in writing, requiring that this subsection shall apply to the notice to quit. And then if that was done, the notice to quit shall not have effect unless the minister consents to the operation thereof. And the minister had delegated his power to consent or not consent to the Agricultural Executive Committee. So the procedure was landlord serves notice to quit, tenant serves a counter notice saying I want section 26(1 to apply, and then the notice to quit has no further effect unless the landlord applies to the Agricultural Executive Committee, which then decides. And the facts are set out higher up on that page. George Martin was the tenant. Landlord served a notice determining the tenancy. Tenant wrote to the landlord saying, in reply to your notice that I received on Saturday, I don't intend to go. I shall appeal against it and take the matter up with the AEC, the Agricultural Executive Committee.
And they were the ones you say who had the power to consent?
Yes. That's apparent from what Lord Evershed says on page 189. If I could invite the court to read not the first paragraph, but the second paragraph, the one beginning, the question turns on the effect of this particular letter.
Yes.
So what the tenant should have said is, I'm invoking section 26(1. Section 26(1 is to apply, with the consequence that the notice will be, he doesn't have to say this, but that would be the consequence, that the notice would be ineffective unless the AEC said it was to be effective. And what he in fact said is, I don't intend to go, I shall appeal against it and take the matter up with the AEC. And that was held to be not good enough to be a counter notice by this court. And then in the last paragraph on that page, he summarises the argument put forward by Mr. Robert McGarry for the tenant. Perhaps I can invite the court to read that. And indeed, perhaps I can invite the court to read to the end of the Master of the Rolls judgment. So the first point I want to make about the Master of the Rolls judgment is that he applied what we now call the Mannai test, but it was a test that was very much being applied by judges long before Mannai, except in the Hankey and Clavering situation. He says the sideline passage in green, not to be construed with great strictness, clear intention to invoke the right which the Act gives. And he refers to Price and Mann, and perhaps it's not necessary to turn it up, but in Lord Steyne's speech in Mannai, he says that the judgment in Price and Mann, which was Lord Green's judgment, was much closer to the modern standard of commercial construction than Hankey and Clavering. Price and Mann was a case where...
Is that a more damage case?
Yes, my lord. It's a page, maybe we'll have a quick look at what Lord Steyne says about it on page 173.
Yeah.
So it was a case where a notice to avoid disclaimer given by the landlord requiring the tenant to retain the lease was invalid. It was argued that it was invalid because instead of referring to section 11, which was the right section, the notice referred to section 10. And Lord Green states the test at letter G. The person who received it and who had familiarity with the provisions of the Act which a recipient of the document must be presumed to have could not possibly be under any illusion as to what it was intended to be and what its legal consequences were.
How does that fit in with what Mr. Justice Aldous said about working knowledge of the Agricultural Holdings Act, which he apparently did not ascribe to the ordinary landlord, whereas Lord Green says that you must assume that the recipient has a familiarity with the Act?
Well, in my submission, what Mr. Justice Aldous was saying was it doesn't matter whether the recipient has a working knowledge. He didn't decide that point. He said whether they do or not. this is not a notice requiring arbitration, can't be read as a notice requiring arbitration. And in the Manford and Hodgkinson case, the point I was seeking to make was simply that the test that Lord Evershed was applying was not some stricter test than that which is the Carradine and Aslan test. It was the Mannai test, not to be construed with great strictness. All that's required is a clear intention to invoke the right which the Act gives. But he says it's not enough that any reference to legal rights is communicated. You have to make it clear that you're identifying the correct right, which is entirely consistent with Stradbroke and Mitchell. Yep. It's the type of mistake that can be corrected. You get the section number wrong, but it's clear what section you're referring to, that can be corrected. If you get the section number right, but the right you're invoking is not the right, that can't be corrected. And the mere fact that you clearly want to exercise a right, and there's only one right you could exercise, is not good enough. That's what Manford and Hodgkinson decided. Lord, one other case I wanted to look at very quickly is the Carradine and Aslan case itself, which is at tab 5.
That was a past date case.
Yes, Lord. It was it's one of two examples in the authorities bundle where, ironically, there is a typographical error in the head note. Well, not in the head note, in the law report. It's in the law report in this one, and in the head note in another one. In this one, it doesn't matter for what I'm going to say, just if the court is looking at the case later and is puzzled by it, there's a typo on page 443 at letter G.
It says 17th when it means 27th.
Oh, not exactly.
It's all explained in the judgment speech of Lord Gough in Mannai.
My lord, exactly. At this point I feel entirely redundant. Yes, it was a case where the date was an impossible one. It was and the test at page 444 at letter G to H is the familiar one, which was approved in the speeches in the House of Lords by the majority. The passage I wanted to draw attention to was on page 65. Two parts of it. What Justice Goulding said on page 65. The first is just above letter B, when he says, I suppose a break clause can be said to be more in the nature of an option conferring a benefit than a clause providing for a notice to quit in a periodic tenancy. The latter, like the former, is a unilateral document which has to be sufficient in form and contents. It acts by its own force to release a given party for an obligation otherwise lying on him. And that is an important feature of notices of this kind, that they are what has been called a performative notice or a performative utterance. They alter the rights of the parties. In the inner house in the Belgrave case, the court described the notice as a juristic act. And then the other point is the illustration that Mr. Justice Goulding gave at letter E, when he said, it is true that if whoever made the mistake had typed 1976 instead of 1973, the error would probably have been incurable, because although the tenant might suspect that there was a slip, it might be that the landlord did intend 1976, not knowing or understanding his rights under the lease. In such a case, the tenant would be entitled to disregard the notice, but because a past date was given him a notice, it is insensible. And we submit that that's still the position. That the key point in the Mannai case was that it was evident that the tenant wanted to determine the lease on the third anniversary of the term date, but had got the date wrong. But if he'd given some other date, which couldn't possibly have been intended to be that, then one would be left saying, well, the tenant wants to determine the date on a date he can't determine it under. He may be exercising the rights under this clause, so he may be purporting to exercise a right he doesn't have. That again supports our submission that the only sorts of error that Mannai can correct are what Lord Steyn called minor errors in describing and identifying and communicating the correct right not errors in the right, identifying the right itself.
Is that right? Looking at those words on page 65 at letter E, the error would probably have been incurable because although the tenant might suspect there was a slip, it might be the landlord did intend 1976, not knowing or understanding his rights under the lease. Why can't you say exactly the same in Mannai? Although the landlord in Mannai might suspect there was a slip with the tenant, it might be the landlord did intend 12th of January, not knowing or understanding the rights under the proviso. And you say, well, it's because in Mannai the notice itself said in accordance with clause 713. But this notice says, on page 62, in pursuance of the proviso. What is the distinction between Mannai, where, as you showed us earlier, Lord Steyne rejects the submission that it doesn't work because it could have been the landlord misconstrued the lease, didn't understand his rights. And here, Mr. Justice Goulding says, well, if the tenant thinks that it could be a legal error, it wouldn't work.
Lord, in answering my Lord's question, I'm trying to find the part in Lord Hoffman's speech where he says the reader would reject as improbable that the sender only wanted to terminate on the 12th and not the 13th.
Yes, he does say
He regards that as...
He does say that.
Yes.
Sorry, that's...
I think I tried to run a similar argument in a case called Garston. Spectacular lack of success in this court.
It was implausible, Lord Hoffman said. Mr. Venison will track down the line for me. It's implausible, Lord Hoffman said, that the reasonable reader would say, well, the thing the landlord really wants to achieve is termination on the 12th of January, and therefore that part of a notice should, or perhaps might, supersede the first part of the notice where he refers to a clause which only allows him to terminate on the 13th of January. But if it's not implausible, if it's a year in the future...
It's at the very, very bottom of page 176. He will reject as too improbable the possibility the tenant meant, unless he could terminate on 12th of January, he did not want to terminate at all.
Yes. And if it's not too improbable, if it is a possibility, a reasonable possibility, but what the landlord really wants to do is terminate on an impossible date, the notice will be ineffective, which is what Mr. Justice Goulding was saying. So, Lord, I propose now to turn to the 4 cases in which the name of the addressee was incorrect, and in which the court said that invalidated the notice. The first one is the Morris case, which is at tab 19. This case concerned a building in Chelsea, and one of the flats in the building, in Cadogan Square, was held under a long lease. Under the legislation at the time, the Landlord and Tenant Act 1954, Part 1, if the tenant under a long lease at a low rent was in occupation of the flat when it expired, then the lease would continue at the ground rent reserved by the lease, but the landlord could secure payment of a fair rent under the Rent Act by giving the tenant a Section 4 notice, specifying the date on which the tenancy was to come to an end and containing proposals for a statutory tenancy. The notice had to be given to the tenant. But in this case, there was a head lease, presumably of the whole building, although the report doesn't say, but one would expect it to be of the whole building. And there was an underlease of the flat. Both were granted in 1962. Both were due to come to an end in September 1995. The original tenant under the underlease of the flat was somebody called Mr. Barnby, but in 1979, he assigned the lease to Mr. Fry, and in 1987 Mr. Fry also acquired the head lease, so he was both the head lessee and the under lessee. In April 1995, so a few months before the end of the term, Cadogan, the freeholder, served a notice under the 1954 Act proposing the creation of a statutory tenancy, and it was addressed to Mr. Barnby, tenant of the premises known as second, third and fourth floor flat. And the notice was served on Mr. Fry. One sees that on page 279 at paragraph 6.
So this is a case where the notice was served on the right person,
Yes.
but the wrong name was in the notice.
Yes. And Mr. Fry, paragraph 6, Lord Justice Mannai says the cases throughout proceeded on the basis that the notice had been served on Mr. Fry. And Cadogan's case here and below was the notice was invalid in consequence of the failure to name the tenant rather than by reason of non-service of the notice on the tenant. So yes, exactly. And if one looks in the last sentence of paragraph 5, one sees the terms of the notice to HHJ Barnby, tenant of the premises. The previous sentence says Cadogan's notice proposing a statutory over tenancy was not addressed to Mr. Fry, who was the tenant of the flat at the relevant date, but was only mentioned in the notice as a person living at a different address having an interest superior to the tenancy of the addressee, because Mr. Fry was the head lessee. And the argument was that the notice should be interpreted as addressed to Mr. Fry, and the argument is set out in paragraph 9 on page 280. May I invite the court to read paragraph 9?
Yeah. One looks at the parenthesis in paragraph 11 on page 67 of the report. I mean, the natural reaction of somebody receiving an envelope addressed to somebody else is not to open it.
But Mr. Fry, we know, was served with it. I mean, he was the head lessee. He was mentioned in the notice by name. And certainly the argument was not that it hadn't come to his attention.
No, it was argued on the basis that he had been served with it.
Yes. The case, Lord Justice Mannai's decision was not based on the parenthesis, but
No.
the parenthesis is just a throwaway comment.
Yeah. But anyway, you say we're bound by this, as was the judge, and it, essentially you say that concludes the case in your favour.
Yes. And the reason it concludes the case in our favour, we submit, is because the mistake that Mr. Fry, or a reasonable person in Mr. Fry's position, would appreciate had been made was in identifying the correct person to be served, to be addressed. I shouldn't use served. I use addressed. And that's what Lord Justice Mannai says. It was expressly and unambiguously addressed by a name to somebody different. And he says it wasn't a minor error or slip. That picks up what Lord Steyn said at the end of his speech.
Lord Justice Mannai doesn't seem to ask himself, what would the reasonable recipient of this notice have thought? Does he? He just says, well, you can't, Mr. Barnby can't mean Mr. Fry.
Yes, that is true. But if the notice had said Mr. Fryer, for example, or Mr. Fries, or something that was a typographical, didn't get the name right, but was clearly trying to identify the right person, then I submit the result would have been different. It's not that one ignores the need to correct obvious errors. It's just the type of error that one can correct.
I think the third line on page 281 is where he deals with how the reasonable recipient would construe it. The reaction of the reasonable tenant would be to think that the notice was meant for Mr. Barnby. That effectively is a rejection of his suggestion that he would think it was meant for Mr. Fry, and that Mr. Fry had just been misnamed.
Yes. But the reason for that is that there was a real person called Mr. Barnby who had been the tenant 15 and a half years earlier and hadn't been the tenant for over 15 years. But if one is to take the approach of attributing to the reasonable recipient an attempt to apply the facts and the law as known to both parties in this case, one would say, well, it can't possibly have been intended for Mr. Barnby as tenant of the flat because he hasn't been the tenant of the flat for 15 years. What is the point of addressing a notice to Mr. Barnby, tenant of premises? He hasn't been here. I haven't seen him for over a decade. So the reason that Lord Justice Mannai says that it must be meant for Mr. Barnby, it can only be because it refers to a real person who had been the tenant, who was no longer the tenant. And an error in getting the tenant right, as opposed to an error in describing the tenant, is not an error of the kind that can be corrected. Otherwise, the case would have been decided the other way.
And you say, therefore, that in the reasonable reader's ambit of what the context was, one wouldn't include, Mr. Barnby ceased to be the tenant more than 15 years ago. QED, it can't be him, it must be me. In the same way, you would say in this case, it should not have been included in the context for the reasonable reader that the landlord didn't know about the assignment.
Oh, yes. My lady, yes, precisely.
Do we know whether Cadogan knew of the assignment from Barnby to Fry?
I think I read somewhere that actually it was just a mistake in their files and they did know.
I think that came from Mr. Jordan's skeleton argument.
Perhaps it did.
The possibilities are that they had been told at some point but had misrecorded it, or that they'd never been told and hadn't inquired. We don't know, is the short answer, my lady.
Thank you.
I did speculate, but speculation is not a helpful guide to deciding what this case decided, so I'd ask that that speculation be struck from my skeleton. The next one is my Lord Justice Lewison's decision in the Linney case, which is tab 20. And this was a case where there was a 10-year lease granted by a company called Capita to the tenant Linney, and it had a break clause which allowed Linney to break the lease after 5 years by giving written notice to the landlord. And then Capita granted a concurrent or overriding lease to Standard Life. so that Standard Life became the immediate landlord of Linney. And Linney served the break notice addressed to Capita and gave a copy to Standard Life's agent, Jones Lang. And there were two issues in the case. The first was whether Standard Life was indeed the landlord, or whether Capita was the landlord for the purposes of the notice. And my lord held that the landlord was the immediate landlord, Standard Life, not Capita. And then the second issue, which is the one relevant in our case, is whether giving a copy of the notice to the real landlord's agent was sufficient to operators' notice to Standard Life. One point is at page 290, at paragraph 20. My lord drew an analogy between break notices and notices to quit, which we have seen Mr. Justice Goulding did in Caroline and Aslam as well. A lot of these cases, or all of these cases, are about break notices rather than notices to quit. But in my submission, there isn't and shouldn't be any distinction in the approach of the courts to notices under statutes, notices under leases pursuant to an express provision in a lease, and a notice to quit. The next point is the argument, which is summarised on page 289 in paragraph 16. And paragraph 16 in the last sentence, the submission is recorded by Mr. Siegler of Queen's Counsel appearing for Linney. He said that service on James Lang LaSalle, I think it's Jones Lang LaSalle, the Standard Life's agent, was good service, and that a reasonable recipient of the notice in the position of James Lang LaSalle would have realised the reference to Capita was an obvious mistake. That was the argument. And then page 291, paragraphs 23 to 25. If I could invite the court to read those paragraphs, please.
Yes.
So, my lord treated the Morris case as being on all fours, which indeed it was. It was a case where the notice was served on the right person but addressed to the wrong person, and that wasn't an error that could be corrected. It was an error, but not the sort of error that could be corrected. And paragraph 24, my lord said there was an additional point, an additional factor, that if the reasonable recipient had looked at the lease on receipt of the notice, he might have formed the view, as Linney's own solicitors did, that Capita was the right person. So it is permissible to attribute to the reasonable recipient something less than perfect knowledge of the law. And in the present case, it's worth reflecting on the position of a reasonable farmer in the position of Mr. Thomas receiving our notice. If Mr. Thomas had studied the law of landlord and tenant, then of course he would have realised that a notice to quit addressed to somebody who was no longer the tenant couldn't be effective. But if he was a farmer who hadn't studied the law of landlord and tenant, he might not have known that, and might have thought that the solicitor who was sending the notice knew what he was doing and was serving the right notice addressed to the right person. That would be an equivalent of the error suggested in the Linney case. And the point made by my lord at paragraph 25 is one that we asked the court to give weight to. The exercise of a break clause has important consequences for both landlord and tenant, and there are powerful policy considerations for certainty in this area of the law. If there is a principle that a notice addressed to someone who used to hold an interest but no longer does, or never held an interest, but it is served on the person who does hold that interest, is invalid, then everyone knows where they are. If it's sometimes valid and sometimes invalid, and it's all very difficult to work out whether it's valid or invalid, then everybody will be left in a state of uncertainty. Advisors won't be able to advise with confidence on what the position is. The next case, my lord, is the Ben Cloyce case, tab 3. There's a typo in the headnote in the first line. It was 25-year lease, not a 15-year lease. So there was a 25-year lease of an office building. The landlord's interest was assigned to a company called Ben Cloyce Estates Limited. The landlord company was the wholly owned subsidiary of a company called Bonnytoon Estates Limited. Bonnytoon Estates Limited owned the only share in Ben Cloyce Estates Limited. Mr. Cairns was a director of both companies, and he was the company secretary of both companies. And the registered office of both companies was the same building. And one gets that from paragraphs 13 and 16. If I could ask the court to look at page 42. The bundle. If I could ask the court to read paragraphs 41 and 42. So this was a case where the notice was addressed to somebody who was not the landlord, Bonnytoon, but it was served at the registered office of the landlord and read by the director and company secretary of the landlord. And there were two issues that the court had to consider. The first was whether the notice had been given to the landlord, and the court said it had not. And the second was whether, given the circumstances that led up to the service of the notice, there was what Scots law calls a personal bar, but we call estoppel, preventing Ben Cloyce from denying that the notice had been validly served by delivering it to Bonnytoon. And on that point, the Inner House held that there was a personal bar. But the relevant issue for us is the first issue.
Yes.
And the argument in favour of construing the notice as being served on the landlord, Ben Cloyce, even though it was addressed to Bonnytoon, is set out at page 43, paragraphs 51 and 52. 51 is drawing attention to the opening words of the lease, which
Yeah.
said that Faraday Properties, hereinafter referred to as the landlord, which expression shall include their successors in title. And then paragraph 52, or perhaps I can ask the court to read paragraph 52.
Yeah.
So the argument is that just as in the Mannai case, the key thing was to identify the clause, and make it clear you wanted to exercise the right under the clause, and therefore the date was an error which could be corrected. So here the key thing was to identify that the notice was addressed to the landlords, which it did, and the fact that the name was wrong was an error that could be corrected. And at paragraph 54, one can see the cases that are cited by senior counsel, which included Mannai, and also included three other English authorities, Lemabel, Speedwell, and Leyen Ackerman. And then if I could ask the court to please to read the submissions at 55 and 56 as well.
Yes.
So in our submission, that is essentially the case that the claimants, respondents are putting in this case, and that the judges below accepted. And the court rejected it, and the court's discussion begins at the top of page 46.
Yeah, the pursuer is saying in paragraph 58 that the question is whether a notice could be said to be given to the landlord if it was addressed to another party. So this is an addressed case.
Yes. And what I draw attention to, I would ask the court to read paragraphs 59 to 65, which is the court's judgment.
Yes.
But they didn't say that the law in Scotland is different to the English. We've been shown English cases, but they're not applicable. That wasn't the ratio of the case. As far as one can see, the judges didn't regard the English cases as inapplicable in Scotland. They just regarded them as not leading to the conclusion that the tenant sought. So perhaps I can ask the court to read 59 to 65.
Well, the last couple of lines of 60 are very unequivocal.
Yes.
Is it true that recorded delivery post requires a named addressee?
Well, I'm content to take it from me in the house that is the case. I haven't ever
Is this-
myself
this
attempted
was
to send.
This was recorded delivery, sent to Mr. Thomas.
Yes. I haven't myself ever attempted to send a recorded delivery letter without a name, so I can't say whether it's possible. But certainly the court proceeded on the basis it was necessary. I suspect the reason is because there needs to be a signature. The person delivering it doesn't just push it through the door. They have to make sure that somebody signs for it.
Well, not necessarily the person named on the envelope.
Not the person, no. Even if that is an error, even if it is possible to send a recorded delivery letter without putting a name on it, if you do put a name on it, then that is the person to whom it's addressed.
Yes.
Yes.
And I do, of course, see that paragraph 62 is sidelined. I do particularly rely on paragraph 62 because the reasoning there is quite strongly applicable in our case. The court thought it was significant in weighing up the argument that the notice should be interpreted as addressed to the landlord, whoever they may be. But that isn't what the notice said, because the notice said, we refer to the lease in respect of which you are the current landlord. That must be read as an assertion that Bonnytoon are the current landlords, rather than as an observation addressed to whichever party was the current landlord, whether Bonnytoon or some other party. And in our case, the notice said, which you hold of me as tenant, which is materially the same.
Yeah. So they agree here with the Lord Ordinary, who I see was Lord Reed.
My lord, yes. And this is entirely consistent with the decision in Morris and in Linney. The last case is Balgray and Hodgson, which is at tab 21. No, it's not. Tab 22. Sorry? Tab 2, I'm so sorry.
Tab 2.
Tab 2, page 21, not tab 21, page 21, sorry.
Now this case adopts a slightly different approach, doesn't it? This says you don't get as far as Mannai. Mannai's got nothing to do with it. If you've got the wrong person, that's it. You've failed to satisfy a condition. That's a blue paper, pink paper sort of point, as I read it.
Well, Lord, my submission is that this case is applying Benthleut, but with one additional feature which makes it worth citing as an addition to Benthleut. And the additional feature is that there was no requirement in this case for the notice to be written. And that was the feature which caused the land court to decide the case in favour of the tenant.
Yeah.
The key point is the one sidelined in green on page 28. A notice in Benthleut required to be in writing, which is not the case with the notice under section 72, subsection 6. But that distinction falls away once a general partner chooses to give what he intends as a section 72.6 notice in the form of writing. Having chosen writing as the medium of giving notice, the juristic act which the general partner must perform, if he is to exercise the section 72.6 power, is to give notice in writing to the landlord. And the land court had said, if one looks at the bottom of that page in paragraph 30, about 8 lines up, the land court signals its change of course as follows: that there is no requirement for written notice means that we are not as tightly bound to the terms of the notice as was the court in Benthleut. And that, the inner house said, was wrong. So it can't be suggested that the fact that a notice to quit can be given orally is a ground for distinguishing the cases that we have looked at. And this was another case where the notice needed to be given to a limited company. The limited company was Balgray. It was in fact addressed to a director of Balgray, Mr. Jardine Patterson, who read it and understood it. But the inner house hadn't been given to the landlord. That was just a straightforward application of Ben Cloyth, which the court said it was following.
Yeah, I misremembered actually. It's paragraph 64 of Ben Cloyth, which says it's got nothing to do with Mannai. On page 47 of our bundle. They say nothing turns on the construction of the notice. It was invalid because it wasn't given to the landlord. The stage of determining, considering how the notice would be understood by the recipient is not reached. So they do say this is a pink paper versus blue paper point. You don't get into Mannai.
Well, they certainly treat the question of addressing as separate to the question of the contents. They accepted that the contents of the notice were clear and unequivocal and wouldn't have confused anybody. And Mr. Cairn said in evidence he wasn't confused. He knew perfectly well what it meant. But if a notice had been addressed to Cloyth Ben instead of Ben Cloyth, it would have been saved by Mannai. It's not that Mannai is inapplicable completely to the question of who a notice is addressed to, but what it can't do is turn a notice addressed to Bonnie Toon into a notice addressed to Ben Cloyth. It's not the sort of error. That's an error not in expression, but in the substance that you're trying to communicate.
Yeah.
And if I can just go back to 2 paragraphs in Valgrave, page 29. First is paragraph 32. Paragraph 31, they record the finding of the land court that Mr. Jardine Patterson had received the letter and had understood its intended import as he was directing mind and will of the appellant, his knowledge could be attributed to it. So there's no doubt that in that case, Valgrave Limited, through Jardine Patterson, its directing mind and will, knew, read and understood the contents of the notice. It was served on Valgrave. But that was insufficient to make it a notice to Belgrave because it was addressed to Mr. Jardine Patterson, the director of Belgrave. And paragraph 32, the inner house says the land court was wrong. And the first and fundamental and simple and short point is the notice has to be given to the landlord. And it wasn't given to the landlord, it was given to somebody else. And the same is true here. The common law, a notice to quit has to be given to the tenant, which in this case was the company, and it wasn't. It was given to somebody else. It was given to an officer of the company, and that's not good enough.
You said at common law, there's actually a statutory requirement under the Agricultural Holdings Act, isn't there, to quit the tenant?
No, common law. There's no requirement in the Agricultural Holdings Act. What there is in the Agricultural Holdings Act is a right for the tenant to serve a counter notice, given the notice by the landlord. Sorry, Lord, perhaps I'm missing my Lord's.
So does that mean that if, for whatever reason, the notice at common law is good, even if not given to the tenant, time for serving counter notice never runs?
Well, a notice of common law has to be given to the tenant, so I'm not sure the question could ever arise, my Lord. Common law, if the tenant is a company, the notice has to be addressed to the company, as I've attempted to explain, as Woodfall says. And under section 72(6) of this statute, the notice has to be given to the landlord, not somebody else. And it wasn't good enough to address it to the directing mind and will, the human being who embodied the landlord, had to be given to the landlord. And the law is the same in England.
Section 24 of the Agricultural Holdings Act 1948 said that where notice to quit an agricultural holding on part of agricultural holding is given to the tenant thereof. But that's not repeated in the 86 Act.
It is.
Yeah,
So
26.
Yeah, there's a given to that.
It is the giving to the tenant that starts time running.
Yeah.
Exactly.
I'm sorry, Lord.
So I'm sorry, I thought I slightly misunderstood therefore what you said.
Yes, it's entirely my fault. The 1948 and now the 1986 Act build on the common law. And the starting point is that typically a tenant of agricultural land would hold under a yearly tenancy which could be terminated by 6 months or more notice expiring at the end of a complete year of the tenancy. And in the 19th century, various statutes were passed to provide aid to tenants and gradually improve their position, and eventually, in 1948, a Consolidation Act was passed, bringing them all together under one roof. And then that was amended many times, and then the amendments were brought together in the 1986 Act. But they all start from the common law of yearly tenancies and notices to quit. And the basic scheme of protection is short-term arrangements are turned into yearly tenancies, fixed-term tenancies are followed by yearly tenancies. So yearly tenancies are created where they wouldn't otherwise be, and then the tenant is given protection against notices to quit. But the Act doesn't itself define what a notice to quit needs to do or what form or contents it needs to have. That's all dealt with by the common law.
Apart from its length.
The length is changed by section
35.
It has to be 12 months,
12 months.
whereas at common law it could be 6 months.
That's section 25 on page 367. A notice to quit shall, notwithstanding any provision to the contrary in the contract of tenancy of the holding, be invalid if it purports to terminate the tenancy before the expiry of 12 months from the end of the then current year of the tenancy.
Your point is that there's nothing in the Act which tells you how to serve a notice to quit or what a notice to quit has to consist of. That's left to the common law, apart from the 12-month extension. But section 26 does assume that a notice to quit, in order to be effective, has to be given to the tenant.
Yes, that is exactly right, and I'm sorry it's being so slow to get there.
Yeah.
There was one other point I wanted to make about Balgray. Sorry. Page 29 again. So in paragraphs 32 and 33, the court is saying that the land court got it wrong. They said it was enough that the contents came to the attention of the right person, Balgray Limited. And in paragraph 33, they emphasise the need for certainty. And I need to show the court this because in the claimant's skeleton argument, it is said the law is different in England. But in my submission, it isn't. My Lord Justice Lewison in the Linney case also drew attention to the need for certainty. In paragraph 33, the Inner House said, in this area of the law there is a need for certainty. To the extent that this is possible, parties need to know their respective positions and thus need to be able readily to ascertain whether or not the notice has been given. And that is, in my submission, precisely what was said in the Linney case. And then the law must therefore provide a bright line test. The bright line test that is being addressed here is you have to address the notice to the right person, and if you don't, it's not enough that it is served on and comes to the attention of the right person. That is the bright line test that is being identified in Balgray.
I think somewhere in one of the Scottish cases there was a reference to English law being different in one respect, which was the effect of an assignment in breach of covenant.
I will ask Mr. Benison to track that down, my lord. There are differences, of course. One difference, which was relevant in Balgray, which is that in Scotland, a partnership is treated as a legal person, which is why this scheme was able to be developed, whereby a landlord would let a farm to a limited partnership, of which the landlord was a member. And then if the landlord wants to get rid of a tenant, the landlord would just dissolve the partnership, so destroying the identity of the tenant and bringing the tenancy to an end. That's why the Agricultural Holdings Scotland Act 2003 gave a right to the tenant in that situation to claim the tenancy for himself rather than it being destroyed. So there are differences, but not, in my submission, any differences that are relevant to this case. But we'll see if we can find that for my lord.
Yeah.
But again, in the Balgray case, if the notice had been addressed to Balgravia rather than Mr. Jardine Patterson, if it had been an evident linguistic error in the communication of the addressee's name, then the Mannai principle would have applied. It's not that Mannai is inapplicable to identifying who the addressee is, it's just that it doesn't enable one to read a notice addressed to one real person correctly identified as being a notice addressed to another person who should have been correctly identified. So it is said by the claimants that Val Gray and its bright line test is not the law in England, and the case that's relied on for that proposition is Pease and Carter. That's at tab 17. This was a Carradine and Aslan type of case where a notice warning a tenant that possession proceedings would be begun gave a notice a year earlier than the year in which the notice was served. The notice was served in November 2018, and it said that proceedings won't begin before November 2017. The decision of the county court judge is summarised at page 203, paragraph 12. So it was a case where the county court judge held that if the Mannai test was applicable, then the notice was valid. But the Mannai test wasn't applicable, the judge thought, because of a decision of the Court of Appeal in Fernandez and MacDonald. And what the judgment of Lord Justice Arnold is primarily concerned with is the question of whether Fernandez and MacDonald did indeed decide that the Mannai test doesn't apply to notices under the Housing Act 1988. And he says that the Mannai test does apply. And if I could ask the court to look at page 213.
Slightly curious case, isn't it? Because if I understood correctly, the point was whether proceedings could be brought. And although the judge said that the notice wasn't compliant, he dispensed with service. So the proceedings were brought, weren't they? Or not? I misunderstood.
I don't think so. I think on page 204, just above letter C, the judge said it was just...
Oh, it had no power, yes, to do...
He'd like to have done it, but he felt he couldn't.
Yeah, I understand. Sorry, misread it. Yeah.
Mr. Benison will correct my rather hazy recollection of how it works, but there are some grounds where you can dispense with a notice and some grounds where you can't. And ground 8, which is the mandatory ground, you can't.
Yes.
Is that right? Yes.
All right, so we look at Mannai.
So most of the judgment, as I say, is concerned with the question of what Fernandez and MacDonald decided. And Lord Justice Arnold says it didn't decide what the county court judge had thought it decided. And on page 213, paragraph 47 is his decision on that point.
Yes.
And this is a passage that the claimants rely on, and they say, well, Lord Justice Arnold says there is no bright line test in England, so when the Inner House says there is one in Scotland, the law must be different. But with respect, that is to mistake the fact that there are two different bright line tests being referred to. What Lord Justice Arnold is talking about is errors of the kind that can be corrected using the Mannai test, specifically the wrong date, a date in the past, which can't possibly be the right date. And he's saying it's not necessary for there to be a bright line test ignoring Mannai completely when analysing whether notices under the Housing Act 1988 are or are not valid. Whereas what the inner house was talking about was a bright line test in terms of a quite different sort of error, which the Mannai test can't correct, which is the addressee of the notice. It is worth noting how Lord Justice Arnold and Lord Justice Underhill described the Mannai test on page 211 at paragraph 39. Lord Justice Arnold says, the conclusions I draw from the survey of the authorities as follows: the statutory notice is to be interpreted in accordance with Mannai. That's to say, as it would be understood by a reasonable recipient reading it in context. And if a reasonable recipient would appreciate that the notice contained an error, for example, as to date, and would appreciate what meaning the notice was intended to convey, then that's how the notice is to be interpreted. That fits entirely with the language in Mannai itself.
Yes.
And Lord Justice Underhill said much the same on page 215. And he adds at the end at letter C, I would add, as regards to, that there must be no reasonable doubt as to what the notice was intended to say. So those are the authorities that we rely on, and we say that Pease and Carter in no way detracts from the force of those authorities. And our submission is, as I have said, that Mannai is about identifying objectively what information the sender appears to be intending to communicate. And if it is clear what that intention is, but there's an error in the expression of the intention and no reasonable doubt about what the notice was intended to say, then the error will be corrected. But if the error is in what the sender intended to say as opposed to how it is communicated, then Mannai doesn't apply. And in the present case, the notice to quit was addressed to Mr. Thomas as tenant. The notice said in terms that he was addressed as the tenant of the holding. It wasn't addressed to anyone other than Mr. Thomas, and no reasonable reader would have read it as intending to say that the company should quit the holding. And the fact that Mr. Thomas was the directing mind and will of the company and read the notice can't convert the notice from one addressed to Mr. Thomas to one addressed to the company. And in addition, a reasonable farmer in Mr. Thomas's position wouldn't necessarily have appreciated that it was a mistake to give the notice to him because of the assignment to the company. And this does produce a fair and sensible result, because any well-advised landlord will serve a Section 6 notice, in which case there can't be an assignment. And any well-advised landlord will use saving words to make it clear that the notice is addressed to a named person or whoever else may be the tenant of the holding for the time being, just as is done with the date. And that result will produce clarity in the law, mean that landlords and tenants will know whether notices are valid or invalid. Nothing to stop a landlord who served an invalid notice to quit from serving a valid one. It's not like you only get one chance to serve a notice to quit.
You may be right that it promotes clarity, but I think it's stretching it a bit to say that it's a fair result. This landlord had no reason to think that his tenant was anything other than Mr. Thomas. And yes, you've explained how he could have protected himself against the possibility of there being an assignment without his knowledge. But if he doesn't know that there's been any assignment or have any reason to think there's been an assignment, it seems to me that it was entirely reasonable for him to assume his tenant was the person he'd let the land to. Anyway, that's a comment more than anything else. You don't need to persuade us it's fair, you just need to persuade us it's the right result.
Well, Lord, all I would say, and it may be completely beside the point, but if one is to attribute to Mr. Thomas a knowledge of the law of landlord and tenant so that he appreciates that an obvious mistake has been made, that could be said to produce an injustice, since the one thing he clearly didn't appreciate was the need to serve a counter notice under section 26.
Or he might have taken the view that he was going to win on the wrong tenant point and didn't need to serve, couldn't serve a counter notice, because if he served a counter notice, he'd be accepting the notice to quit had been given to a tenant, which was the last thing he wanted to accept. So he may have had a very sophisticated knowledge of the Act rather than none at all.
Well, if a reasonable person in his position could have thought the notice was correctly addressed, then Mannai can't save the notice.
Yes.
In this case, he was right, in which case we win. But if the judges below were correct, then one's left in an unhappy position that the notice is valid because a reasonable person in his position would have appreciated what the law of landlord and tenant was, but it's plain that he didn't, because he didn't serve at least a without prejudice counter notice. Your notice is invalid, but just in case it's valid, here's a counter notice. So just to conclude, if I may just briefly identify what we say are the errors in the reasoning in the judges below. In the core appeal bundle at tab 15 is the judgment of His Honour Judge Jarman. And page 165, paragraph 27 is the core of his reasoning. The question he asks himself is, would a reasonable recipient in those circumstances appreciate that the notice should have been addressed to the company and was intended to be valid to terminate the tenancy? In our submission, the question is not whether a reasonable recipient would have appreciated what the notice should have been addressed to, but what meaning a reasonable recipient would understand the sender of the notice to be seeking to convey by the words they have used. It's a different question. And if that question had been asked, the answer would have been the meaning that the sender intended to convey was that Mr. Thomas, as tenant of the holding, should vacate it. And then he says, in my judgment, the answer to that question is yes. Well, that assumes that Mr. Thomas has a good working knowledge of the law of landlord and tenant, and that's not a correct assumption to make. The next point he makes is it is plain that a reasonable tenant reading the notice could not be misled by it and could be in no doubt of the identity of the intended recipient. But the intended recipient was Mr. Thomas, not the company. So in deciding that a reasonable recipient would be in no doubt that the company was the intended recipient, the judge erred. And then he says there was no prejudice to the company. In these cases, the courts have not focused on the question of whether the recipient is prejudiced, but on the question of whether the notice satisfies the requirement that it be addressed to the person it needs to be addressed to. One wouldn't say that Mr. Cairns or Ben Cloyh or Val Gray or Mr. Jardine Patterson or Standard Life were prejudiced. That isn't a question that's discussed in the cases or thought to be relevant, and it isn't relevant. And the judgment of Mr. Justice Zacaroli is at tab 9. And on page 88 of paragraph 38, the learned judge said that he was satisfied that the reasonable recipient would have no doubt that the notice was intended to convey an intention to require the person who was in fact the tenant to deliver up possession of the land. That is quite inconsistent with the approach in the cases that we have looked at. It would be to treat the name of Mr. Thomas and the fact that the notice says Mr. Thomas holds the land as tenant as being struck from the notice.
Well, I mean, Mr. Justice Zacaroli is clearly right that the notice was intended to require the person who was the tenant to give up the land. I mean, that's the whole point of serving a notice to quit. Your point is that doesn't answer the question.
Well, if one changed it to the person who the sender thought was the tenant, then of course it would be right.
Yeah.
But what Mr. Justice Zacaroli is saying, it doesn't matter that they got the name of the addressee wrong. You should interpret it as a notice to whoever happens to be the tenant. But that is inconsistent with the cases we have looked at, and it's wrong.
Is Mr. Justice Zacaroli right to frame the only question in the way that he does at 35? Your point, I thought, was that a notice which is addressed to A and sent to A cannot be a notice given to B.
Yes.
Whatever test you apply, it just can't be. So it's not, on that view, it's not a question of interpreting a notice at all. It just fails. It's a blue paper versus pink paper point, as the inner house said in Ben Kluch. You don't get to Mannai.
Mannai would apply if there was an obvious error in the spelling of the name of the person who was being identified. If it was clear that the right person was being identified, but there'd been a mangling of the language used to refer to that person, then Mannai would apply in full force. But where it doesn't apply is where there's no error of linguistic expression. The error is in what the sender is trying to say rather than the language they're using to say it. And yes, my lord, paragraph 35 is wrong. And paragraph 43 is also incorrect. The learned judge said it was obvious it was intended to be addressed to the company. Well, with respect, it was obvious it wasn't intended to be addressed to the company. Couldn't possibly be read by any reasonable recipient as addressed to the company. In my submission, the decisions of the courts below are quite inconsistent with the four authorities that we rely on and are based on a fundamental...
You would say that really what Mr. Justice Zacaroli is saying at 43 is it's obvious it should have been addressed to the company, not that it was intended to be addressed to the company.
Lord, I gratefully adopt that way of encapsulating what I'm trying to submit. Yes. As in the Manford and Hodgkinson and Stradbrook and Mitchell cases, it's not enough that it's clear that somebody is trying to exercise a right and you know what they should have done in order to exercise the right. That isn't enough. That's in the category of cases referred to by Lord Steyn as out with the ambit of correction of obvious linguistic errors by construction.
Yeah.
So unless I can help further, those are my submissions.
Yeah. At some point you'll deal with Lazarus. And
I will. I plan to have a look at that over the shorter German.
By all means.
Deal with it subsequently if I may.
Right. Yes, Mr. Radley Gardner.
My lady, I'd just like to start my submissions by perhaps refocusing on what is at issue in this appeal, because in my respectful submission, there is a slight risk of drift that has emerged from our learned friend's submissions. The way the case was argued, both at first instance and in front of Mr. Justice Zacaroli, was purely on the basis of Mannai. In other words, the notice, there was never an issue in this case that the notice wasn't given or served on the company. The problem in this case was what the notice said on its face. That was what the focus was about. And the reason I just wish to emphasize that is that the fact that the notice was given to the company is one of the agreed factual matters on which this case proceeded. The reason why I'm concerned to press that on the court is that when dealing with the Scottish authorities, it seemed to be suggested that actually there might be an additional point here, which was the company given the notice at all?
Is that in the agreed statement of facts?
Well, it's in my learned, as I had understood my learned friend's responsive skeleton argument at the end. So it's the supplemental skeleton argument at tab 6. my understanding from the way in which the appellants were conducting the case was that the problem with the judgments below was that essentially Mannai was being applied to a type of error that Mannai could not in fact reach, and that is what the courts had got wrong. What I had not understood, at least in those terms, to be the case that was the appeal that was being advanced, was the suggestion that it was now being said that the notice had not been duly served on the company.
I thought Mr. Jordan accepted it had been served.
It had been served.
Because of Section 93.
Yes.
But it needs also to be addressed to the company.
Which is a question of what it says on its face, which is why I wanted to emphasise that at the start, because as your Lordship, Lord Justice Lewison pointed out, in the Scottish cases, in both of them, the court in each case said we're not at Mannai because we don't get to the position of the notice reaching the correct, as it were, letterbox.
Yeah.
So we're not in Mannai territory.
That's how I read those two cases.
I respectfully would agree with that reading of those cases.
It's a blue paper, pink paper point.
But where we are in this case is that the letter has got into the correct letterbox. It's just the question of whether the person who's read that letter is entitled to say, well, I don't know, this is not addressed to me, this has got the wrong name on it, whether that is fixable. We're looking, as it were, at the question that the Scottish courts considered didn't arise. Can this notice be corrected by Mannai or not? So that's the first point I think is important for this court, respectfully, not to, as it were, lose track of, that we are dealing with the question which neither of the Scottish cases thought was up for debate in those cases. The second point that I would just like to make is the one that emerged from the argument of my learned friend and his discussions with this court. Whether or not there is an error is a question of how generally you frame the question. My learned friend's submissions are that the only error that the legal tipex that Mannai can correct, the only errors that are relevant are errors whereby what is written on the page does not match what is in the brain of the author. There has been some disconnect between the author's intracranial thoughts and what he writes down on a sheet of paper. In my respectful submission, there is no basis in any of the cases for limiting Mannai to those sorts of errors. And as my Lord Justice Nugee pointed out, in Mannai itself, the landlord wrote down the 12th of January. There is no suggestion that he meant the tenant wrote 12th of January. There is no suggestion that the tenant meant to write 13th and slipped on the keyboard. The landlord, the tenant in the Mannai case, wrote down exactly what they meant to say. It was just the wrong thing. It was an error in substance in the mind of the landlord, which nonetheless was capable of being corrected. So my learned friend's submissions in relation to Mannai and the limitation of Mannai is based upon a distinction between two categories of error, which I respectfully suggest don't find any basis in the cases. And I'd just like to develop that, if I may, by starting out with consideration of Mannai, and in particular with the 5 principles which were identified by Lord Steyn, which I suggest are a very helpful route map through this particular thicket. And the relevant passage which I'd like the court to look at, please, is in tab 10 of the authorities bundle. No, it's not in tab
14.
I beg your pardon.
Mannai's tab 14.
Tab 14, I beg your pardon. Tab 14. And on the top right-hand pagination of the law report, the relevant part of Lord Steyn's judgment is at 767. And it's about halfway down that page.
Yeah.
And I suggest it's useful because it draws clear parallels to exactly the problem that we're looking at in this appeal, and explains exactly why, in my respectful submission, the courts below were correct. Lord Steyn starts with his conclusions before undertaking what he described as the gruesome autopsy of the cases that have gone before, And the 5 principles which he sets out start with the first proposition. This is not a case of a contractual right to determine, which prescribes as an indispensable condition for its effective exercise that the notice must contain specific information, which I think is my Lord Justice Lewison's point that some clauses, of course, have a blue paper, red paper, pink paper requirement. They're just, the key doesn't fit the lock in Lord Gough's terminology. They are so phrased that certain formalities must be obeyed.
But might it not be said that giving notice to the tenant is one such?
It would be, my lord, if it were not for the common law rule that the notice to quit can be given to just the tenant. There is no need under, and this is common ground between the parties, there is no common law rule and no contractual modification of that common rule and no statutory imposition of any further rule that the precise tenant be identified.
No, but you do have to give notice to quit to the tenant.
Correct.
Giving notice to quit to someone else has no effect at all.
That's correct. But the notice
you just don't need to name the tenant. You can give a notice
precisely
to an individual and say, "I want you to go."
Yes, precisely. But one can, on common law, stand outside the front door without naming the tenant and shout, "Get out of that house by a specified date."
And you could do it in writing.
And you can
put a notice through the letterbox saying to the tenant,
"Yes,
you are required to quit by."
So the reason why I think the first proposition is illuminating is because precisely the point that my Lord Justice Lewison has raised is considered by Lord Steyne between paragraphs F and G. The break notice in that case, he points out, could simply have been expressed to determine the lease on the 3rd anniversary of the commencement date and would have been effective. So as here, the notice to quit simply expressed to refer to the tenant without any attempt to identify who that tenant is would equally have been valid. So there is no precise lock into which the key has to fit. There is no obligation to identify by name the tenant. Indeed, if one then digs into the common law requirements and tries to understand precisely what level of particularity is required, it is not even necessarily clear that one has to refer to the tenant in the notice. And the only case I found that discusses that, or rather that was cited below, is the Townsend's case, which is at tab 24, the bundle of authorities. We haven't gone to it yet. And I refer to it simply because it's the only place I've been able to find in which the courts have considered the question of the level of particularity with which a tenant needs to be identified in a notice to quit. It's a judgment of McGarrett Vice-Chancellor, and the relevant passage is within the law report at 365 to 366. And if I may, could I just invite the court, please, to read from 365 halfway down, paragraph starting, "No authority cited to me was directly in point," and then down to about halfway down page 366.
The general agency is a different point, though, isn't it?
It is, except that, as the court goes on to observe, that first of all, there is no reason why an agent has to disclose that he is acting as an agent, and that the court decides is equally true of the giver as to the receiver of the notice. And then over the page...
Yeah, it's this last case, it's that paragraph that you rely on.
Yes.
The distinction between addressing a notice and giving a notice.
Precisely. And he then goes on to say, obiter, if the notice was addressed to the wrong person, but was nevertheless delivered to the right person, the question would be whether the misaddressing prevented the notice from being given to the right person. He then says the purpose of a notice is, of course, to convey information. And if the notice, despite its being misaddressed, suffices to convey the requisite information to the right person, I would have thought that it would satisfy the terms of the lease. So that's the closest I've come to a discussion of this kind of misaddressing situation. And the reason why I think, in my respectful submission, that is important, is when one looks at Lord Steyne's first proposition, the clause that he has in mind is logically similar to the problem that we are grappling with. Because what's happened in the Mannai decision is that somebody has over-complied with the requirements of the contract by specifying a date when they did not need to do so. And the question then is by reason of that over-compliance, which posited an erroneous date, is the person giving the notice prevented from relying on it because it's invalid? And Lord Steyn says in his first proposition that the answer to that is no. You are not prevented from relying on the validity of the notice, provided that the error can be corrected. It is not a pink paper, blue paper situation. And the reason why it isn't is because the clause can be satisfied at a high level of generality. And in my respectful submission, that's equally true of the common law rules relating to the notice to quit. That reasoning is directly mappable onto our case. The fact that the landlord chose to do something that it didn't actually in law have to do, the fact that the landlord inserted a name into the notice that it in fact in law was not required to do, either at all on the basis of the Townsend case or at least only at a high level of generality as agreed between the parties, that is an error which, according to the first proposition of Lord Steyn in the Mannai case, is capable of correction. So in my respectful submission, this case falls exactly within the first proposition as advanced by, as set out by Lord Steyn. It is not, there is no indispensable condition in his words at common law or contractually or in statute that the tenant is named in the notice. So one gets over, in my respectful submission, the first hurdle. The second proposition, which Lord Steyn then moves on to, is how one then looks at the notice which contains an error which is not an error in some indispensable condition for validity. And as was canvassed in submissions earlier, the question is not how the landlord understood the notices. The construction of the notices must be approached objectively. The issue is how a reasonable recipient would have understood the notices. And in considering the question, the notices must be construed taking into account the relevant objective contextual scene. Over the page, he explains that the contextual scene would include that the reasonable recipient of the notices would have had in the forefront of his mind the terms of the leases. So the recipient of the notice is a legal expert to the extent that, at least on this formulation, the reasonable recipient will have in their hand the leases and will have the terms of the lease at the forefront of their mind, and that the reasonable recipient in this case will be able to do that which the actual landlord did not do, which is work out the correct date. So to that extent, the reasonable recipient is imbued with a degree of omniscience, because he has at the forefront of his mind the lease, he construes that lease correctly, and that allows the reasonable recipient to identify that the landlord has made an obvious mistake in formulating the date on which, in this case...
Is that realistic if you're serving notice to quit on a farmer?
Well, it depends on the level of technicality of the document that's required. But in this case, we have a common notice to quit, and the defect that is identified is that obviously the name on the document is the name of the farmer as a natural person and not his legal entity, his legal personality. So if I could put it this way, your lordship is saying, well, he can't understand a notice to quit, but he is sophisticated enough to be a tenant of Erskine Chambers and understand the nature of corporate personality, and that this notice which is addressed to him should in fact have been addressed to him in his corporate capacity. Either way, one is proceeding on an assumption of either a farmer at Falcon Chambers or a farmer at Erskine Chambers. But the reality of the situation is, my lord, that the contextual scene that Lord Steyn says one has to posit is that this is a farmer under a lease, and that farmer will know facts that are relevant to his interpretation of the notice. He will know that he has 3 days before the notice was received assigned his lease by deed, which we have in the bundle, to a company that he has specifically incorporated That is a permissible piece of the factual scene that we're allowed to translate over into the reasonable recipient in the hypothetical world. The other fact that we're allowed to translate into the hypothetical world which the reasonable recipient inhabits is the fact that he knows that the landlord does not know that. That is the other relevant factor that the recipient in the hypothetical world will be aware of. And that sets our hypothetical recipient farmer apart from some of the other persons that we know from the cases. For instance, the Morris case. In the Morris case, an assignment took place 16 years before the notice was served. And the person who received that notice will know that the landlord also knew that, because for 16 years he's presumably been paying ground rent or something of that nature.
I'm not sure that's right. Kodaka was the freeholder, and the relevant tenant, Mr. Fry, was an underlessee. He wouldn't have been.
That's true. I'm sorry. Yes, that's correct. But in any event,
it's not obvious to me from my quick glance at the report whether Kodaka did or didn't know that Mr. Fry was the underlessee. There had been an assignment from Mr. Barnby to Mr. Fry. What one can say, as Mr. Jordan said, is that the Court of Appeal obviously didn't think that was a relevant question.
No. But if I can then instead focus back on our hypothetical recipient, those are material facts that our hypothetical recipient knows. I have incorporated a company. I have assigned my tenancy to that company, and nobody else apart from me knows that. And in those circumstances, in my respectful submission, again, the reasonable recipient of the notice, as the courts found below, would have realised that a notice was being given to him as tenant to terminate the tenancy of the holding. And that notice, which was intended to achieve that purpose, could only have achieved that purpose in relation to the company, so that the natural person who was named in the notice will have known that what the landlord meant to do was to terminate the tenancy, and had the landlord known of the existence of the company, would have addressed the notice to that company. But because he knew the landlord...
Again, I mean, we run into the problem of the level of generality at which you put the question.
Yes.
I mean, in the Scottish cases, they wanted to exercise a right. The only way they could have done was to serve notice on a particular person, which they didn't do.
Yes, but in that case, we're not discussing what we're discussing in this case, which is, of course, we're at the level of Mannai in this case, whereas in that case, as I indicated at the beginning, both of the Scottish cases were concerned to point out that these notices were not given, and we don't get to Mannai, but we are in Mannai.
Well, that is that simply because of the way the case was argued below?
Well, my lord, it was accepted that under Section 93, under the extended service provisions under the AHA, it's valid service to give the notice to the person who is either an officer of the company or the director.
It's been served on the company.
Yes.
But does that necessarily mean it's being given to the company?
Well, in my respectful submission, the answer to that question is there a defect in the notice which is curable by Mannai, yes or no? And in my submission, the first proposition advanced by Lord Steyne is directly analogous to our proposition. There is no pink paper, blue paper rule that the common law imposes on a landlord serving a notice to quit. The landlord has, in inverted commas, over-complied or gold-plated, if one can put it that way, by inserting the name of a tenant. It is the wrong name. Is that as Lord Steyne puts it, an indispensable condition that has not been satisfied? The answer is no. It is a dispensable option rather than an indispensable condition that has been exercised by the landlord. It is not so fundamental a requirement of the common law as to fall within bring us into pink paper, blue paper territory. So once one gets past the first proposition, one is in Mannai, and one then sets the scene as required by the second proposition. And I take your lordship's point that then one gets into a position of at what level of generality does one operate. But the fact of the matter is here that the landlord in this case has served a notice which is trying to bring about a particular result, the termination of the tenancy by notice to quit. The tenant is the only entity that knows that the landlord has written the wrong name on the notice. The tenant knows the landlord doesn't know that to be the case. And in those circumstances, I'd respectfully adopt the conclusions of the courts below that it is patently obvious to the recipient of that notice what it is the landlord is trying to do. And it's patently obvious that the landlord has made a mistake on the face of the notice, and he's made that mistake because the landlord has imperfect knowledge. And in my submission, it's wrong in principle to do what, in my submission, the appellants are coming very close to doing, which is to focus on the nature of the landlord's mistake. Was it a transcription error of a genuine intention, or was it a mistaken intention itself? Because that is inviting you, the court, to focus precisely on the wrong mind in this problem. You are not required, one is not required under the Mannai principles to have any regard whatsoever on the intentions of the giver of the notice. The nature of their mistake is a matter of entire indifference to the Mannai test. The focus is on what it is that strikes the recipient upon receipt of the notice. And it does not matter whether the reason why the recipient is named as a natural person is because the landlord knew there was a company but just made a drafting error, or because the notice went to the natural person because the landlord made a mistake as to who his tenant was, because the tenant had ceased to be the natural person and become a corporation. So the reason why there aren't cases discussing, or the reason why the modern cases don't discuss the nature of the error which is made by the landlord, as my learned friends suggest is relevant in their skeleton argument, is because the mind of the landlord is entirely irrelevant to the question. It is the reasonable recipient test. So, my lord, when one then accepts that we are not in pink paper, blue paper, which I respectfully submit is what the first stage of Lord Steyne's principles requires one to identify, one then gets into the scene that is set for the reasonable recipient. And it's always difficult, of course, to make submissions about something that's a matter of impression, because that's a highly subjective matter. But in my respectful submission, once one bears in mind that this is a notice to quit, that the tenant is imbued at least with an awareness of the lease, because that is what Mannai permits one to do, and that the tenant knows what he knows, which is that the tenant knows that he knows he's carried out an assignment to a company and is at least that sophisticated. And we also know what the tenant knows other people don't know, which is that the landlord is unaware that the company has become the new tenant. Then in those circumstances, a tenant in receipt of a notice to quit seeking to bring to an end the tenancy will appreciate that the landlord has made a fundamental mistake on the basis of its ignorance. So in my respectful submission, therefore, the requirement of obviousness is made out. Indeed, on our factual matrix, there is no other candidate who could possibly be the addressee of the notice to quit. It satisfies that other requirement in Mannai, because, of course, it's fatal to a Mannai argument if, as was, for example, decided in the Linney case, there was scope for doubt as to who the real addressee of the notice was meant to be. And your lordship made that point in the Linney decision, in which you said, well, everyone could have been equally confused in relation to whether it should be Capita or Standard Life, who is the addressee. So, amongst other reasons, the Mannai argument failed because there was no last man standing who could have been the addressee of the notice. But here there is one last man standing, which is the corporate entity, the company, to which the lease has been assigned.
So you would say you fall into the third proposition of Lord Steyne on page 170 of the bundle,
Yes.
at the end there, one would expect that if a notice unambiguously conveys a decision to determine, i.e. it is a notice to quit,
Yes.
a court may nowadays ignore immaterial errors which would not have misled a reasonable recipient. And you would say it's immaterial because you didn't even have to put a name in there. You could just Tipex out that line.
Yes. As was said in the opening and argument, and I think accepted, if somebody had Tipex out the offensive line, that notice would have been absolutely fine. Where in this case, the appellant's case comes in is that the appellant thinks, well, hang on, the giver of this notice hasn't understood the nature of corporate legal personality, as opposed to being a natural person, and seeks to put forward that technical argument. Whereas I do make the point that the notice has one obvious function. There is only one person who can obviously satisfy that function, and that person's identity is locked away in the inmost breast of the first respondent, first appellant in this case, the natural person. But I then say, yes, it leads one on to the third proposition. It also then brings one, in my respectful submission, to simply skip past the fourth proposition, which is that, as Lord Steyn makes clear, this applies to all notices. There is no special rule for notices to quit or break notices, or statutory notices, or contractual notices. The test that's simply postulated, and this is what Lord Steyn says halfway between letters G and H, the test postulates that the reasonable recipient is left in no doubt that the right reserved is being exercised. And in this case, nobody is suggesting that there is any doubt in the mind of the recipient of the notice. The way that the argument is being advanced is that this is a mistake of such a profound nature that Mannai cannot reach it. But the problem with that are the facts of Mannai itself, in which the notice specifies the wrong date, and it's not suggested that this is a sort of rectification type problem where the intention has been mistranscribed. Mannai seems to be a case in which the wrong intention was formulated and then correctly written down. But the reason why that doesn't matter is because we are not being asked to investigate the mind of the giver of the notice. We are being asked to investigate the mind of the receiver of the notice, and only that person's mind, that person being translated into the hypothetical world Lord Steyn requires us to imagine. That then brings us to, I'm sorry, my lord, shall I'm about to move on to proposition 5, but I can interrupt it now.
As you please.
I'm very happy to leave it there and then come back and
All right.
talk about it.
2 o'clock.